think it was because it was on my dock and something happened.
With their mic setting?
Yeah.
Is it, do you see the Zoom currently in use?
All right, council member, you're off mute, just FYI. We're waiting on Councilmember Pinto, and once she gets here, we will get started.
Councilmember Parker, this is Marquez in room 120. Whenever you're ready to start, we're ready.
Okay, sounds good. I think we're all here now. I am receiving a notification that I can't turn on my video because it's disabled by the host. So if my team can help triage that for me. All right. And Marquez, I am ready when you are.
You can start, Councilmember.
Good afternoon. I am Councilmember Zachary Parker, Chair of the Committee on Youth Affairs. Today is January 27, 2026. The time is now 2:04 p.m. We are holding this additional meeting virtually via Zoom, given the weather conditions here in the district. I am calling to order this meeting of the Committee on Youth Affairs. We have a quorum consisting of Ward 2 Councilmember Brooke Pinto, as well as our newest colleague at large, Councilmember Donnie Crawford, and myself. We welcome Councilmember Crawford to the committee, and I look forward to working with her to continue improving outcomes for youth across the district. During today's markup, the committee will consider and vote on a total of 9 measures, all of which have had public hearings conducted by this committee over the last few months. This includes our public hearings on November 13th, 2025 and November 19th, 2025, as well as our confirmation roundtable on December 11th of 2025. We want to thank all of the government and public witnesses, key stakeholders, and especially the youth who have submitted written testimony on these measures, shared their lived experiences and conversations with me and my staff, and offered their thoughts and feedback on these bills to help us get them to this point. The first of these measures is PR 0-0358, the Director of the Child and Family Services Agency, Tanya Torres Trice Confirmation Resolution of 2025. This resolution advances the mayor's nomination of Acting Director Torres Trice to be appointed as the permanent director of the Child and Family Services Agency, or CFSA. As detailed in the committee report, Acting Director Torres Trice received widespread support from the child and welfare community during our public hearing. Those who have worked closely with Ms. Torres Trice were enthusiastic about her nomination and spoke to the incredible leadership qualities she has exhibited during her 17-year tenure with the agency. We have heard from her neighbor, I will repeat, her next door neighbor, about her caring and empathetic nature and the strong qualities that make her an excellent fit for this role as director. As I mentioned during the committee's public hearing on the resolution, I have continuously been impressed by Ms. Torres Trice and her willingness to work closely with the council to ensure positive outcomes for CFSA involved youth, and I look forward to continuing our work together should the committee vote to advance her nomination today. The remaining measures for today's consideration are part of the Care for Youth Plan, or Coordinating Assistance, Rehabilitation, and Empowerment for Youth Plan, which I was proud to introduce this past October. The Care for Youth Plan is a 16-bill legislative package that seeks to uplift, inform, and streamline several issues related to CFSA, and the Department of Youth Rehabilitation Services. The legislative package was primarily born out of the Committee on Youth Affairs' extensive performance and budget oversight. Numerous conversations with youth and other key stakeholders over the last year have pointed to the need to make reforms in both the child welfare and juvenile justice systems, and I'm confident that these bills will make great progress on this front. Today, we will vote on 8 of the bills in the package. I am very proud of the work that went into crafting each bill and ensuring the youth voices were at the very center of the process. The committee staff took careful and intentional steps to integrate public comment into the committee prints, and the committee reports outline in detail each of the changes we incorporated. I look forward to advancing these bills, and I urge my colleagues to support them as we move them forward for full consideration by the council. Before we move on, I would like to offer my colleagues here today an opportunity to offer opening remarks if you have any. Councilmember Pinto.
Great. Well, thank you so much, Chairman Parker, for holding this markup today. And I want to really congratulate you on moving forward such an impressive and comprehensive package of bills that are really going to support our young people and our families today. I think it is a huge testament to the vision you have and the amount of work you and your team have put into this mission. As you talked about some of the different bills, I just wanted to mention a few things that I'm most excited about. The Care for Youth Plan, I think, is going to make really significant reforms to ensure that our kids and families are safer and treated with more dignity that everyone deserves when they're interacting with our government agencies, both on the local and the federal side. It is extremely needed. And I'm voting to support all of these 8 bills today, as well as the confirmation resolution. Really appreciate your work on the SOUL Act and all those who have been a part of the SOUL Act to create a new legal permanency option for our kids who are involved with CFSA, known as a SOUL family. And I thought that the testimony that we heard at the hearing was particularly powerful around that important change. The new permanency option is going to enable our kids to acquire a stable network of supportive adults who are really able to provide housing, care, and mentorship. And I think is an important reminder of what we can do when things are not in such silos and we're considering the entirety of the need. In 2023, I was proud to work with Councilmember Nadeau on the Vulnerable Youth Guardianship Amendment Act, which established a special kind of guardian to ensure that the legal rights, care, support for non-citizen youth between ages 18 and 21, as we recognize that the existing system had many gaps for this particular group. And I think what you've done here with SOUL promises even more encompassing changes to support our young people under and coming out of the foster care system. My team and I have been in conversation with the Children's Law Center, the DC Family and Youth Initiative, the Youth with Lived Experience in the district's foster care system, known here as Lived Experts or Lived Experience LEX leaders. And I want to uplift and recognize the Lived Experts and LEX leaders for their years of work and their ongoing work and partnership that has really been instrumental to bringing this important legislation before us today and to this point. And for those LEX leaders tuning into this markup, I hope that you are very proud of taking your experience and all of your great insights and work to getting us to this point today. So congratulations to you all as well. There are other bills in the care package that make meaningful improvements to the care provided to our incarcerated youth in DC. And I want to again thank you, Chairman Parker, for you and your team for directly working with youth, families, and advocates to identify these solutions to ensure pregnant youth are provided the health care they deserve, that parents are included in young people's rehabilitation plans, which is so important, and that data reported by DYRS and OAG on youth recidivism rates is transparent and aligned between both agencies. You know, we're always going to have a continued debate in the city around who can have access to what records. And I think when it comes to all of the public safety strategies and investments that we are looking towards in the future, it's so important that we are starting at a baseline of consistent data. And so I think this bill helps us get there. Several of these bills were also jointly referred to the Committee on Judiciary and Public Safety, which I chair. And so just want to say for the record that I look forward to moving these bills through my committee in the next couple of weeks. And Chairman Parker, you and your team have really been true partners with our committee in making DC safer for all residents. And so I'm proud to support this package, and thank you again and congratulations.
Thank you, Councilmember Pinto. And I would echo your shout out for those Lex leaders. I'm told they wanted to join us in person today, but the weather precluded them from doing so. And so I'm hoping they are tuning in, and we will take up the SOUL Act and other bills momentarily. Okay, not seeing any other comments. We're going to jump right in.
Well, I also have an opening statement. Sorry.
Okay, sorry about that.
No, it's okay. I just want to congratulate you, Chairperson Parker, and your team for all the work that you put into these 8 bills. I know you've been holding the hearings and you've been really taking time to meet with stakeholders on all 8. And I know it took a lot of time to get to today. So congratulations. I'm also really excited to support the SOUL Act. So I'll echo Councilmember Pinto's comments. And I'll also say I really like the Statutory Neglect Amendment Act as well, and its focus on making sure that we're eliminating the potential for racial and economic bias by establishing that poverty cannot be the sole basis for a finding of neglect. And I think that's very, very important. And that bill in particular has a lot of common sense updates to it. So thank you for that. And those are my statements. And thanks for welcoming me to the committee.
Yes, we're super excited to have you.
Thank you.
And it's really cool to be able to say Councilmember Crawford. For those that are not familiar, Councilmember Crawford served as a staffer for a long time, and now is serving as our at-large council member. I would just say before we move forward, some may be wondering, we're talking about 8 bills being marked up today, although we've referenced a 16 bill package. There are a couple of bills that the committee has held back that we're still working on with stakeholders, and other bills have been referred to the committee of the whole, and we are looking forward to those moving swiftly as well. So with that, first, the committee will consider and vote on PR-0358, the Director of the Child and Family Services Agency, Tanya Torres Trice Confirmation Resolution of 2025. This resolution advances the mayor's nomination of Acting Director Trice to assume the permanent directorship of the Child and Family Services Agency. Ms. Torres Trice is a licensed social worker with over 20 years of experience working on behalf of children and families. Her experience includes 17 years at CFSA, including as Assistant Deputy Director and Administrator for the Office of Youth Empowerment, and most recently as CFSA's Chief of Staff. In writing about her interests in the directorship, Ms. Torres Trice shared that she is, quote, driven to lead CFSA to strengthen our community partnerships, address systemic issues, and ensure that every service decision is made with the child's and family's best interests in mind, end quote. Ms. Torres Trice is also a Ward 5 neighbor. The committee finds that Ms. Torres Trice is significantly qualified for this position and recommends approval of her confirmation by the council. Is there any discussion on this specific bill? Hearing and seeing none, the vote will be on PR-0358, the Director of the Child and Family Services Agency, Tanya Torres Trice Confirmation Resolution of 2025, with leave for staff to make technical, editorial, and conforming changes. All those in favor, please say aye.
Aye.
All those opposed, please say no. And the ayes have it unanimously. Next, the committee will consider and vote on B 26-30398, increasing support for grandparent and close relative caregivers. B 26-0398 increases the grandparent and close relative caregiver subsidy to $38 a year in fiscal year 27 and adjusts for inflation annually thereafter. This bill was the result of numerous grandparents and close relative caregivers sharing with the committee about the immense costs that they take on when they step up to take care of children into their home and at a time of immense need. It is important to understand that the rate for these subsidies hasn't changed in roughly a decade. The current full subsidy payment without TANF benefit offsets is $24.79 per day for children younger than the age of 12 and $27.92 per day for children older than 12. Given the ever-rising cost of raising children in the district, the increasing support for grandparent and close relative caregivers Amendment Act of 2025 seeks to address financial struggles head-on and more fairly provide support for kin caregivers. The committee print does include one significant change. We heard testimony from the executive that we found persuasive that raising the age limit would both add to the possibility of creating a wait list for these programs and be difficult to implement. The committee print therefore removes the section which raised the age of eligibility to the age of 21 as we seek to do more work on this. This bill would focus primarily on increasing the subsidy rate as mentioned. Is there any discussion? Councilmember Crawford.
Thank you. I just briefly want to say, I took a look at the fiscal impact statement. I'm a little concerned with the high cost, but I understand that we need to increase the subsidy. It's been over a decade. The amount, the 25 million over a year, CFSA expects the number of participants to remain steady. So I'm hoping to work with you as we take up the budget to see if there's a way we could get more participants, as well as maybe figuring out how to get the cost down.
No, thank you for that. I too was a little taken aback by the cost, and I'm looking forward to working with the committee as well as the agency. It's worth noting the agency supports the idea of raising the subsidy, and it's a matter of finding the means and resources to do so. So with that, all those in favor, please say aye. Aye. All those opposed? And the ayes have it unanimously. Next, the committee will consider and vote on B 26-0399, the Support Opportunity Unity Legal Relationships, also known as the Sole Amendment Act of 2025. B 26-0399 sets forth a new permanency option known as a sole family, which allows foster youth to establish a formal, legally recognized network of stable, supportive adults in their lives. All the elements of a sole family are defined within B 26-0399 and the legal process set forth. I am proud to say that the committee staff and I work directly with Young Lived Experience, or LEX leaders from the Family and Youth Initiative and the Children's Law Center on this legislation. I want to give all the thanks and appreciation to them for their many years of work with CFSA and other stakeholders. This is, to be clear, their brainchild, and I'm proud to be a vehicle and a conduit to bring it to life. I want to thank again the foster youth who came and shared their stories and perspectives with the committee, along with Susan Punnett and Tammy Rasinga Kote for all of their work. So will close the gap for many foster youth aging out of the system without a real network of support. And again, I am hopeful that we can move this swiftly through the council. Is there any discussion on this measure? Okay, seeing and hearing none, all those in favor, please say aye.
Aye.
And any opposed? The ayes have it unanimously. We're on a roll here. The committee will move on to B 26-0400, Statutory Neglect Amendment Act of 2025. B 26-0400 reduces legal ambiguity by creating separate definitions for abuse and abandonment. It adjusts neglect code language. 1 second, I'm sorry. Okay. The bill reduces legal ambiguity by creating separate definitions for abuse and abandonment. It adjusts neglect code language to promote a focus on the condition of the child rather than the parent. And it eliminates the potential for racial and economic bias by establishing that poverty cannot be the sole basis for neglect. This bill was informed by community members, including mothers from the Mothers Outreach Network, who came to testify to the committee about their lived experiences with the child welfare system. The committee also worked closely with the Office of the Attorney General and the Children's Law Center, both before and after our public hearing, to ensure that the bill captures the nuance of the legal system to best support parents and families across the district. The committee print makes several technical changes and importantly removes explicit references to exposure to domestic violence as child abuse and female genital mutilation as neglect after discussions with the Office of the Attorney General that these may be separately prosecuted under pre-existing parts of the code. On that last point, I am very sensitive to the exposure of domestic violence, but was persuaded, particularly from the Office of the Attorney General, that our current laws and code allow for them to take action on that, and that there weren't any necessary changes needed within our neglect code. Is there a discussion on this bill? All right, seeing none, I move to approve the committee print and committee report for B26-0400, the Statutory Neglect Amendment Act of 2025. Will leave for staff to make technical, editorial, and conforming changes. All those in favor, please say aye.
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 Any opposed? And the ayes have it unanimously again. Next, the committee will consider and vote on B26-0401, Youth Records Transparency and Oversight Amendment Act of 2025. This bill requires the chair of the council committee with oversight of the Department of Youth Rehabilitation Services, or DYRS, to be granted limited access to juvenile records in cases concerning delinquency or persons in need of supervision. It also grants the chair of the council committee with oversight of the Child and Family Services Agency be granted limited access to juvenile case records in neglect cases, and that certain juvenile records be made available to the ombudsperson for children to enable the ombudsperson to investigate the failures of the child welfare system in its work. Importantly, B26-0401 adds the relevant council oversight committees and OFC to an existing section of the DC Code that already maintains safeguards to protect the disclosure of information to unauthorized persons. The committee print made one significant change in that it further limits the scope of the access of information to case records and strikes access to the social file. It is worth noting that the committee and I disagree with some stakeholders that suggest that the committee staff and the council members should not have access to the social file. But in an effort to strike a compromise and move this bill forward in earnest, we are limiting the scope in today's markup. This change was in response to concerns raised particularly by the Office of the Attorney General that including the social file would unnecessarily expose information the committee is not seeking, such as social security numbers. My hope is that by beginning first with the case record, the committee will gain insight into the adequacy of this limited information to conduct effective oversight over the juvenile justice system, and that further discussions can get us to a point of fairly and transparently being granted any additional information necessary to fulfill our duties. Is there any discussion on this bill? Councilmember Pinto.
Well, thank you, Chairman Parker. I just wanted to thank you and your team for reaching this compromise. I think, as I talked a little bit about a couple minutes ago, having access to clear data and ensuring that we're all on the same page as policymakers, um, where that data lies, even with our young people, is really important. But like all things, is a balance, and there is a level of sensitivity around including the entire social file that I don't think we need access to and to protect our young people's information and privacy. So just want to thank you for working with us on that issue, and we'll continue to work together to get that balance right, to make sure that we're using accurate data and requiring accurate data regardless of the age of somebody without undermining their privacy. So thank you.
And thank you and your team for your work with us on this. All right, with that, I move to approve the committee print and committee report on B26-0401, the Youth Records Transparency and Oversight Amendment Act of 2025, with the leave for staff to make technical, editorial, and conforming changes. All those in favor, please say aye.
Aye.
Any opposed? And the ayes have it unanimously. The Committee will now consider and vote on B 26-0404, the Safe Pregnancy, Delivery, and Postpartum Care for Youth at DYRS Amendment Act of 2025. This bill requires that DYRS make pregnancy testing available to youth upon admission to a DYRS facility, such as the Youth Services Center and New Beginnings, as well as pregnancy testing when necessary for the prescription of certain medications. B 26-0404 sets the standard of care at DYRS facilities to ensure timely, culturally responsive, and comprehensive care for pregnant youth. These measures aim to fill a gap in healthcare protocols at DYRS, which have fallen short. It is unfortunate that this approach to healthcare has not been more intentional nor consistent at DYRS, but my hope is that this bill is that form of a basis for the health standards that we expect for our juvenile justice system. It is also worth noting that the council has made similar changes for our adult detention system, ensuring that there are protocols in place for pregnancy, delivery, and postpartum care. And this bill largely ensures that there is consistency across our adult system as well as our juvenile justice systems. With that, is there any discussion? Councilmember Crawford.
I believe DYRS originally testified in opposition, and they said that they just had issues with the codification of medical guidelines. Did the committee consider their feedback at all? Do you have a response to that?
Thank you. Yes, the director testified in opposition to the bill, but in that same testimony, agreed with the intent and push behind the bill. Interestingly enough, the committee did work with DYRS and the director, and so parts of the bill have changed. Originally, we were requesting protocols be mandated or created, and we have found out that they do in fact have protocols, and so we've struck that part of the bill. And now what we're doing is mandating that certain care be in place as well as the implementation of the pregnancy tests. And so we tried to strike a balance. But again, I think it's worth noting these changes were made in our adult system by the council, and what we're doing is making these changes in our juvenile system. Another reason why this is important is because independent research or investigations found that juveniles were being administered medications of all kinds without there being sufficient understanding whether or not some inmate or young people were in fact pregnant. And so those medications could pose a risk to the pregnant individual or the child, which is again why having these standards in place makes really good sense in my opinion. I
Thank
hope
you.
I answered your question.
Yes.
Awesome. Thank you. All right. With that, I move to approve the committee print and committee report on B 26-0404, the Safe Pregnancy, Delivery, and Postpartum Care for Youth at DYRS Amendment Act of 2025. Will leave for staff to make technical, editorial, and conforming changes. All those in favor, please say aye. Aye. Any opposed? And the ayes have it unanimously. All right, we're making progress here. The committee will consider and vote on B 26-0407, the Strengthening Capacity and Transparency at DYRS Amendment Act of 2025. This bill requires regular reporting on youth demographics and incidents by the Department of Youth Rehabilitation Services, which were previously the responsibility of the Office of Independent Juvenile Justice Facilities Oversight, an office which sunsetted this past October. Additionally, this bill defines recidivism for juvenile delinquency reporting purposes and tasks DYRS with publishing rates of recidivism in 1, 2, and 3-year increments. Finally, B 26-0407 directs the mayor and the executive administration to create a 1-year action plan to address systemic overcrowding at the Youth Services Center within 120 days of the bill's passage. The committee print makes 2 changes worth noting. The definition of recidivism was changed upon consulting with DYRS and the OAG. Additionally, the 1-year action plan provision originally called for the executive to create a plan for reducing overcrowding at YSC by ensuring the population was at 90 persons or below. The committee adjusts this section to now say, quote, below maximum capacity to ensure DYRS uses its available beds adequately. It is worth noting in terms of the definition of recidivism, we aligned with, as I mentioned, DYRS and OAG, but were persuaded that DYRS's definition was more in line with what we were talking or wanting to achieve for the district, which is essentially noting juveniles in 1 year, 2 year, and 3 year increments after release from detention who have been charged for a new offense and having been adjudicated. And so you'll learn more in the committee print. But is there any discussion on this bill? All right. With that and seeing none, I move to approve the committee print and committee report on B26-0407, the Strengthening Capacity and Transparency of DYRS Amendment Act of 2025, with leave for staff to make technical, editorial, and conforming changes. All those in favor, please say aye.
Aye.
Any opposed? And the ayes have it unanimously. Next, we have B26-0408, the Promoting Parental Engagement at DYRS Amendment Act of 2025. This bill requires the Department of Youth Rehabilitation Services to contact a juvenile's parent, guardian, or custodian at least every 6 months following a planned predisposition meeting and to keep an electronic log of such attempts. This bill was the product of I will repeat, consistent reports to the committee that DYRS is routinely failing to contact parents and families of youth in their care to conduct the planning necessary for a successful rehabilitation. The committee did not make any changes, and the committee print remains as introduced. There was concern raised at the hearing that I will just briefly address, that this was duplicative in some senses, that it overlapped with the Road Act. And I want to stress the committee fully supports the intentions behind the Road Act. And we see that this bill supports the Road Act, and we do not mandate new touch points. It is the expectation that the agency is engaging with parents in a routine, ongoing manner. What this bill largely does is ensure that those are happening at a minimum of 6 month increments, which some would say is not enough. But also it ensures that those engagements are being logged within the systems that DYRS already has. And so with that, is there any discussion on this bill? Seeing none, I move to approve the committee print and committee report on B26-0408, the Strengthening Capacity and Transparency at DYRS Amendment Act of 2025, with leave for staff to make technical, editorial, and conforming changes. All those in favor, please say aye. Aye.
Aye.
Any opposed? The ayes have it unanimously. Next, we have B26-0409, Empowering Parents in CFSA Investigations Amendment Act of 2025. This bill requires the Child and Family Services Agency to inform caretakers of their right to counsel, legal counsel, at the start of a neglect investigation. CFSA must also provide a list of legal resources available and inform the caretaker of the availability of the Office of the Ombudsman for Children as a resource for complaints against CFSA. The revised version of this bill makes it clear that parents must be provided with a list of legal resources at the initiation of a CFSA investigation to underscore the importance of immediate notification of these resources. The language before some thought was ambiguous, that notification could happen during the investigation, and we wanted to make clear that it should happen at the very beginning of the investigation. And the reason why this matters is because we have routinely heard from parents, mothers in particular, that without knowing their rights and without sufficient legal counsel, they face undue harm and stress and anxiety going through this process of being under investigation by CFSA. And we seek to empower parents even as they may be under investigation. So with that, is there any discussion? Seeing none, I move to approve the committee print and committee report on B26-0409, the Empowering Parents in CFSA Investigations Amendment Act of 2025, with leave for staff to make technical, editorial, and conforming changes. All those in favor, please say aye. Aye.
Aye.
Any opposed? And the ayes have it unanimously. Finally, the committee will consider and vote on B26-0412, the Child Abuse Investigation Multidisciplinary Team Certification. I plan to pull this from the agenda, but I do want to speak to it. This legislation seeks to redefine a Children's Advocacy Center, or CAC, to be an accredited Children's Advocacy Center instead of specifying Safe Shores by name. In short, Safe Shores is an independent nonprofit which does laudable work. I support them and their efforts in the district that they are investigating some of the most heinous incidents and crimes against children. The committee believes strongly that even still, an independent nonprofit should not be listed by name in the DC Code in this manner. It also mandates the use of an accredited Children's Advocacy Center during multidisciplinary team investigations by requiring the MDT to make efforts to enter a service agreement. Finally, this bill sought to establish an annual reassessment and designation of the district's Children's Advocacy Center to ensure fair and transparent process for these services. In full transparency, there's been a bit of back and forth with the committee and Safe Shores. And I today have agreed to keep working on this bill. But I want to make clear that it is important that independent nonprofits are treated as such, and that we do not conflate the rights of those organizations with our defined terms of law in DC Code. I think it is important that we treat those very differently. In an effort of good faith, I have spoken with the director of Safe Shores and have agreed to go back to the drawing board on this bill, but that should not be interpreted that we will not take action here or that we shouldn't take action, even though Safe Shores does great work and we support them as an organization. I think both things can be true. So with that, I'm going to table this bill for now as we continue to work on it in the days ahead. With that, the business before this committee is concluded. And I want to thank you both, Councilmember Pinto and Councilmember Crawford, for being here today, but also digesting all of this content and working it through with us. The time is 2:39 p.m. And I'm going to adjourn this meeting of the Committee on Youth Affairs. Thank you. Thank you. Enjoy the rest of your day and stay warm. Thank you all. Thank you. Thank you.